Good afternoon. Thank you for joining us for the Brooks Pierce webinar, Maintaining Business Operations Under COVID-19 and Ongoing Workplace Regulations. A disclaimer before we get started, please note the content of this webinar is provided for general information purposes only. It should not be considered legal advice or used as a substitute for consulting an attorney for legal advice regarding the participants' own matters. I'm now going to pass it over to today's speakers, Beth Langley and Jesse Fowler-Moran.
So broadly speaking, things that we'll be touching on today are the current state of employment laws and regulations, both those enacted specifically in response to COVID-19 and those that have become particularly pertinent in the atmosphere in which we're currently operating. Illegal obligations with regard to your employees who have either childcare issues or school closing issues. We know many of you have been slogging through this for 6 or so months now, and unfortunately, it looks like we're probably heading into another wave of some uncertainty and closures. So just revisiting what's out there and how best to support your business and also comply with your obligations to your employees. And then lastly, as a catch-all towards the end of the presentation, we'll talk about broader ways that you can be protecting yourself and your business from liability for either COVID-19 specific issues or legal issues that are always out there but seem to have kind of risen to the surface in the current conditions. So I'm sure all of you are as tired as I am of seeing these pictures of COVID-19, but here's our segue into the legislation we'll talk about today. And I'm going to spend my portion of the presentation talking about the Family First Coronavirus Response Act, the FCRA, which if you are on this call and you have worked with our labor and employment team this year, you have probably worked with us to implement a policy or process this law. This is legislation that Congress passed this spring in response to COVID-19 and all of the closures and kind of triaging that was going on. And at the time, we had some internal conversations about how remarkable it was that the law only applied to employers with 500 employees or less. And we kept waiting and saying, surely there will be something to kind of close that gap and make it applicable to more employers. And here we are in November, and it still applies to employers with 500 employees or less. So I'm revisiting this law in part because it is in effect until the end of 2020, and in part because for those who either are not familiar with the law or have not implemented it to date, certainly it's better late than never. This is a law that the federal government has indicated they're taking very seriously, and we expect the need for leave to rise before it falls just because of the transients we're seeing, particularly with childcare in schools in relation to spikes in cases. So the FFCRA is comprised of two main components. One is paid sick leave, and the other is extended FMLA leave. If you have 50 or more employees, you probably are familiar with the FMLA already. You should have protocols in place for administering FMLA leave. This extended leave applies to all employers. So again, it's two components. The paid sick leave, very broadly, is 2 weeks of leave calculated either as 80 weeks of paid leave if you are a full-time employee, or your average hours over a 2-week period if you're a part-time employee. And it's paid leave for one of 6 reasons that I will go over here in a minute, but basically that boil down to either you personally, the employee personally, has COVID-19 or has been directed to quarantine, or otherwise given an indication they might have COVID-19 by a professional or government entity, or you are caring for someone either who is subject to one of those directions or a child whose childcare provider is unavailable. So that's a 2-week paid leave window. The second piece of this law is the extended FMLA leave. If you are an employer who is subject to FMLA already, this folds into that 12-week period. What's different about this extended leave is not just that it's applicable to all employers, but that it's paid for everything from week 3 to week 12. So the way that the paid leave is calculated is complicated, and we've spent a lot of time doing math and building charts and those kinds of things. We're happy to talk you through it if you have employees getting ready to go on the leave, or to make sure you have a policy in place that ensures you're paying the right amount of money. But very broadly, the pay that's available is either their full regular pay if they are on leave. It's their full pay for the emergency paid sick leave. And then if you are on leave for either reason because you are caring for someone else, it's 2/3 your regular rate of pay. The FMLA is extra complicated because the first 2 weeks are unpaid unless they apply this paid sick leave or they use PTO. So we've spent a lot of time in the past 6 months helping employers apply this policy, and I still get kind of tongue-tied describing how it works, which is all the more reason it's a great idea if you don't already have a really well-written policy directing your staff how to implement the policy. It's a good idea to put that in place now. So again, here are the enumerated reasons you could be available for this paid leave. Either the employee is subject to a quarantine or isolation order that prevents them from going to work. They've been advised by a healthcare provider to self-quarantine. They themselves have symptoms. They're seeking a medical diagnosis. Or this one that's bolded here, the employee caring for a child of theirs whose school is closed or childcare is unavailable due to COVID-19. And this is, again, one that we've seen come up a lot in the past several months, and that we're seeing come up again as we enter this new phase of restrictions, or because we have employees who have been on leave since remote school started back in August, and we're coming up to the end of that 12-week cycle. So we're starting to see more questions from you all about how to work with employees who are in this situation. And it's a good idea to make sure you've got everything, T's crossed and I's dotted before you move to the next phase. So with regard to school reopenings, school closures, the FFCRA, a reminder that virtual school is considered closed because there's not a child care provider available for your child in that school. Employees who have children whose regular child care provider is unavailable might be eligible for up to 12 weeks of paid job leave. There's a very comprehensive set of questions and answers published by the Department of Labor on the administration of these policies. That would be a great place to start if you have fact-specific questions, or again, talking with your employment counsel, because there are a lot of specific concerns, right? You have some folks who have decided they're not comfortable for safety reasons sending their child back, but that child care provider is unavailable. And that's going to be a different analysis than someone whose child cannot attend to the school that they are regularly enrolled in. And so one great thing to prepare for as we're heading into this next phase is just build into your business plan an assumption that you'll have employees using FFCRA leave, using paid time off, and otherwise just requiring a little bit more flexibility than they might otherwise. And in that note, remote work for some jobs is possible, for others it's not. You can offer remote work as an alternative, but the employee has to actually be able to provide that remote work and care for their children. So the Department of Labor has made very clear and reiterated in some revised guidelines issued in September that they expect employers and employees to collaborate as much as possible to problem solve. I know this isn't ideal. I know that a lot of you are feeling very burnout about trying to run a business in a pandemic. If you have children at home, it's a whole nother wrinkle. But one of the things to bear in mind as you're trying to figure out how to keep the doors open on your business is whether you can work with certain employees to, maybe they log on 2 hours earlier than they normally would and log off an hour later because they have a time in the middle of the day they're not available. It's a time to think creatively about a way to meet everyone's needs. And that helps so that you're not distributing a bunch of paid leave to people who you need to have your business running. If you take the remote work option for any of your employees, it is absolutely key that you have policies and protocols that are communicated to your employees about your expectation that they will record time worked accurately. And this is something that is true even when we're all in the same brick and mortar building. The buck stops with the employer when it comes to accurately reporting time worked. And so it is very much in your interest to communicate to your employees an expectation that they are going to accurately report hours worked and hours off the clock. All right, a note on PTO. You cannot require the PTO to run concurrently with the paid sick leave, which is that 2-week window. You can require PTO to run concurrently with EFMLA. And employees have the option, if your policy allows it, to subsidize that difference between the 2/3 pay for the childcare leave and that last third to get them to their regular rate of pay. Again, prepare for employees to be using that PTO, that FFCRA leave. As you're considering things like remote work and flexible schedules, beware inadvertent discrimination that can happen kind of in both directions. Make sure that your supervisors administering the remote work and the leave are not either being more generous with women who have childcare obligations at home than with men, or perhaps in the other direction, making assumptions that men working at home with children are going to be more productive than women working at home with children. That's a great way to expose yourself inadvertently to a gender discrimination suit, which nobody wants. And Beth will touch on this more towards the end of the presentation, but even before COVID, we were seeing a rise in litigation from fathers challenging companies' failure to provide parental leave on equal terms to mothers. So I expect this is a legal trend we're going to see apart from whatever happens with the remainder of this pandemic wave. And another thing we're seeing as folks are sort of using up the 12 weeks of FFCRA leave if they've been on leave since school started or working remotely, but we're holding employees who have taken that leave or requested that leave to a different standard of performance than employees who have not. And if you've worked with us in the past, we've talked about the importance of providing regular, accurate feedback to your employees with regard to performance issues. This is another moment where tensions can kind of come to a head when you have an employee who's been out or less available for several months. And what you don't want to do is create what looks like a record of having issues with their performance for the first time when they are coming back from some sort of leave, particularly a legally protected leave like this one. So just a good reminder to have those hard conversations when the need arises instead of waiting until things have kind of come to a head, because a lot of times by then, if you ask our opinion, we'll tell you it's kind of too late. We've had a lot of employers ask us over time about exemptions from the FFCRA because it feels like a very big burden on you all as smaller companies to provide this leave. And note, there is an opportunity for exemption. It is very rare to meet the standard, and it very simply boils down to your organization or your business could not continue operations if this employee were permitted to take leave. So it's going to be very rare for that exemption requirement to be met. If you think that you might qualify and you're interested in pursuing it, we strongly encourage you to connect with us, connect with your employment counsel, and really engage in the analysis to and document that in your files to protect yourself from liability as much as possible. That window is very narrow. One way we've seen that play out since the legislation was enacted was there's a carve out in the legislation for healthcare providers, and employers who provide healthcare on the face of the law are not required to grant leave on the same terms as employers who are not. And as a result of a lawsuit that happened in the late summer, we got some revised regulations from the Department of Labor that clarified when someone constitutes a healthcare provider and when they are an employee of a healthcare organization, in which case they're entitled to the leave just like everyone else. So again, if you're tempted to declare a person or yourself as an employer exempt from the FFCRA, we would strongly urge you to revisit that before you act on that conclusion. There is a federal poster for the Notice of Rights under the FFCRA. That's going to be similar to the wage and hour posters that you need to distribute in the proverbial break room or wherever you put these posters up. Again, better late than never. If you don't have this poster up, print it off when you finish this presentation and distribute it. Better late than never. We've seen some indications from the DOJ that they're taking this very seriously. So it's a question not just of civil liability, but showing the DOJ or whoever else comes knocking, that you've done everything you can to administer the policy. In that vein, I've mentioned a few times, we have a policy that we're happy to help you customize for your business, helps to ensure that you're administering the leave uniformly, and really just gives you and your employees a roadmap for what the law covers. There are some payroll tax credits available for this leave to the extent it is provided. But to get that, you have to keep certain information in your files. You have to fill out the US Treasury required certification. And there's not going to be a tax credit if the employer is a PPP recipient. So just things to keep in mind as you are administering this leave. I think that is the end of my section. So I will stop and ask Beth if questions have popped up.
Does anyone have any questions before we move forward?
I did such a good job that nobody has any questions.
And we'll have time later for questions too. Well, so we do have a question. So Jesse, what if you pay out leave after your PPP covered period ends? So if your FFCRA period is, if the FFCRA leave is after that PPP period, is the question.
That is actually a good question. I'm not sure I've looked at that. Do you know the answer?
I think what's going to happen is it's going to depend on whether you, it's going to be a very fact specific question as to whether or not, and I'm probably, I should defer this and say you should talk to your accountant, because it's going to be specific to you on whether you're looking at your, whether you extend your period when you're looking at loan forgiveness, or whether you're going to have keep it to that original time frame. So that's going to be a very fact specific situation.
And
the next question is, what's going to happen after January 1, 2021? Will the FFCRA be extended? There is no indication right now that this leave is going to be extended. Right now, no one in Congress is getting along on on the two sides of the aisle. So we don't have any indication after, after what we're going to refer to as the new administration, because that's the way things are rolling. That's crystal ballish. So, it could be an extension of this act. It could be something new. Next question is, Jesse, I should let you answer that. Okay, this one's for you. What if you have an employee who stays home but does not get tested for over a week? And I'm just going to assume some facts here, but the employer asked them to get tested, but they do not.
So that's interesting, and I'll give my take, and then Beth, I'm curious what you're telling people. The guidelines from the Department of Labor say that an employee who kind of self-diagnoses isn't eligible for the paid leave. From a practical standpoint, the motivation behind passing the paid sick leave legislation was to keep people who are sick out of the workplace so they don't infect others. And so I would say it maybe comes down to the facts of a particular situation, and it's a little bit of a judgment call from the employer. The Department of Labor, again, has said they're not entitled to that leave. But there comes a question in my mind of whether you want that person coming back into your workplace. So that I guess my take is it's going to be a risk analysis specific to the employer.
Yeah. This is a nice segue to the next question, actually. I agree with your analysis. If someone is out multiple times while waiting on test results and goes through their 80 hours, that's 2 weeks waiting for a test result, of emergency sick leave, and then gets sick, do they run out of FFCRA, or do they have to use their own time or go unpaid?
So if they've used their 80 hours, they are out of paid sick leave. So the question then becomes, is there PTO available to the employee? But you may also enter into this murky territory where you have to look at the other alphabet soup legislation available to employees, which might include leave under the ADA, and it might, if you are an employer of more than 50 employees, trigger some kind of FMLA leave, depending on, you know, if this person actually gets sick and tests positive and what they test positive for. I mean, again, it kind of opens a can of worms, but the short answer is their 80 hours is all they get for COVID specific leave, but it does not end the inquiry there.
Okay, here's this last question on the FCRA for now. We'll have some more time. If the employer, if we are not FFA required, so if they have over 500 employees, now, can they also say that employees are not eligible for paid leave? So if they've added emergency sick leave voluntarily, I guess that's what they're saying. So they're not covered by the paid leave portion, but they have voluntarily added emergency sick leave. What would you suggest when employees are out?
So I think the important thing there, if you voluntarily added leave, is to make sure you have a policy that's being administered consistently with regard to what employees get that leave under what conditions. You don't want to inadvertently give rise to some kind of discrimination claim. And then apart from the paid leave portion, I think it's going to be a judgment call with regard to, again, motivating employees who might have COVID-19 to stay home. And so again, visiting maybe your obligations under the ADA or the FMLA, which wouldn't necessarily come with paid leave, or they wouldn't, but also thinking about how to properly incentivize your workforce to keep one another safe.
Yeah, I would also add that if you're 500 or more, then, you know, unless everyone is scattered so much that everyone's, you know, you don't have 50 employees in a single work site, you're still covered by the regular family medical leave. So this will likely be covered under family medical leave. You know, if they're seen by a physician or, I mean, it's likely that the testing itself would count as under a physician's care or even telemedicine these days. So, you know, I would, the most conservative approach is to treat this process of being, you know, trying to be diagnosed and getting the symptoms diagnosed as covered under FMLA.
Which wouldn't bring paid leave necessarily, but would get them.
It would not necessarily be paid leave. I think getting into that paid leave piece is going to, like what Jesse said, is just making sure that you're treating, you're having a consistent approach to how you're applying that. All right, those were great questions.
You ready to dive?
That's why this is still relevant, because it's still coming up. Yeah.
Are you ready to dive in on the ADA stuff?
That's a nice segue to ADA. So I think as most of you are finding, we don't, in dealing with employees and employment issues, it's not, you know, it's not a one issue situation. You know, we have all these other employment laws that we have to take into consideration. So the Americans with Disabilities Act is one of those. Before COVID-19, you know, we all kind of knew what the ADA allowed us to do and didn't do with regard to medical related inquiries. And then all that changed in March, you know, when this was declared a pandemic. And I'm not going to say surprisingly, I'm just going to say refreshingly, the EEOC was very responsive and pretty quickly prepared a website about you know, how to deal with this pandemic from an employment perspective. So here's the link, you know, and we'll post this PowerPoint on our site so that you'll have these materials too. You'll have access to them. But they really dealt pretty early on with what employers can do and can't do with regard to making inquiries, taking temperatures and those sort of things. So, Jesse, let's look at the next slide. So really early on, we knew you could take temperatures. Not long after that, the whole issue about antibody tests came up, and the EEOC modified its guidelines. And I think we were getting, and still are getting, updates on these guidelines pretty frequently. So some things just to really keep in mind, because as we're getting spikes, we're getting people back into work, we're still seeing layoffs. These are some things that really try to keep top of mind. You can't, as much as we would think that you can do this, we can't say, okay, I'm going to screen out the folks from employment who I think are higher risk, or I'm going to go to them and say, hey, I think you ought to sit out. That's a personal decision that the employees have to make. Employers can't do that for them. And you can't, and I'm going to rephrase it another way, you can't do that to them. That's up to the employees to make. Employment decisions have to be made based on skills and merit, and those sort of, those bases. The EEOC was also very clear that employers are not required to make an accommodation based on a family member's risk. And so where that comes up is, say I have an elderly parent and I make a request to say, hey, I know everybody's coming back to work and this is hospitality and I can't remote work and wait tables. Will you make an accommodation for me so I can stay home and not be exposed, not expose my high-risk family member? EEOC says that's not an accommodation under the ADA that someone has to make. Now, let me kind of stop right there. There may be an FMLA issue that you have to take into consideration, but that's not an ADA issue. So you always have to think, well, it might not be this law, but it might be the next one. So we kind of have to go all the way through our alphabet soup of different employment laws. So under the ADA, that's not something that you have to do. I'm not staying in order here, but I'm kind of staying in topic. It is still important if there's a positive test that you notify the health department in the county that you're in. And that's just under regular circumstances, you wouldn't have to do that. That would be a disclosure. You would actually be prohibited under the ADA of notifying the health department. But it's the state and local officials are requiring that, and the federal government through the EEOC is saying, yes, that makes sense now in the time of a pandemic. So there are a lot more topics. Take a look at that website. It's changing pretty frequently. And what we'll see into 2021, I'm being hopeful about this, is that we're going to gradually see it winnow down, kind of back to once we are no longer in a pandemic, hopefully. Again, I'm being hopeful. We're going to see it winnowed back down into what the regular ADA requirements were. But for now, we're still obviously in pandemic mode. OSHA. OSHA has been at top of mind for everybody in the last 9 months. Whereas that, this general duty clause now has become like the beacon of safe workplace for all of us, where that used to be sort of like over here. Of course, it's a general duty clause, but if you're not up on and looking at OSHA's website, at least on a weekly basis, perhaps on a daily, to see what's new, you really need to. And CDC has become the standard for general duty clause. What are those guidelines? What is CDC saying that businesses need to be doing? CDC has broken things down by industry. So it's really important for businesses to be tracking CDC guidance by your particular industry and making sure that you are following what the CDC is recommending. And the reason that is important is at some point, we don't know when, but at some point, plaintiffs' lawyers, I mean, they're already getting busy, but they are already tracking this. And when we see the claims that start falling from all this, they're going to be following the employers who didn't follow the CDC guidance. So just make sure that you're following the CDC guidance, that you're documenting that you're following the CDC guidance. That's the most important thing that you can be doing right now.
And you want to talk about a moving target. If you have spoken with us about COVID safety in the workplace in the past couple of months, we've probably told you that the CDC website has changed. Oh gosh, Beth, what do you think, like once a week?
Yes.
So don't get complacent just because you've looked at it last month.
Absolutely. And one of the real concerns that we have is, the environment that we're in is, people meaning everyone, our employees, our managers, our customers, folks are nervous, they get scared, and say rightly so. And what we're finding is that, say an employee comes to a manager and says, listen, I'm really nervous about the way this setup is over here, because I don't think that's necessarily I read the CDC guidance this morning and that's not the way it should be. That conversation right there can put that employee in a protected category for raising a safety concern. So what we are concerned about is that, say 2 weeks later, there's a layoff. Necessarily so, no ill intent, that employee gets included in the layoff and goes home and says, you know what, I think that I got selected for layoff because I made a complaint about safety. I didn't think things were getting handled right. And, all of a sudden, they see some ad on television for, if you think, you've been wrongly terminated, and they find them a lawyer. Those are the concerns that we have about claims and the maybe volume of claims where there's not, I'm not going to call it happenstance, but it's going to be just by virtue of the sheer number of anybody having a conversation, because so many people have concerns about something. They're going to raise a concern, and the number of people affected by layoffs. I mean, I think it's just going to be a numbers game based on what's happening in our world right now. So we think necessarily there are going to be more retaliation claims, more whistleblower claims. We had a recent case from our North Carolina Court of Appeals that clarified under our Retaliatory Discrimination Act that employee does not have to file a formal internal claim to be protected under RETA. So that now implicates OSHA claims, workers' compensation claims under RETA. So, it's just a different environment. So my advice, not to scare you to death, is just before you make termination decisions, layoff decisions, disciplinary decisions, absolutely make sure that you go through a checklist and see what your liability issues may be. You know, all of these folks who took this extended family leave or paid leave or just regular FMLA leave are in a sort of protected category as well. So just for taking the leave. So things just to be aware of. Jesse, I see we have a question.
I've been scared to put my question box down because I can't tell if y'all can see it when I do. All right, the question is, are you looking at it?
I'm trying to get to it. Okay.
What kind of documentation should we have when following CDC guidelines? We are doing quite a bit, but wanted to see your thoughts. Good question.
Yeah, that's a great question. One of the things that we've been recommending is having like some sort of OSHA, an OSHA or CDC kind of coordinator, and it can, I'm not suggesting creating a new role, but just having someone who is the keeper of all of the COVID-19 or safety protocol. And so have that person document what steps are being taken as far as COVID safety. So if there is a change in procedure or a change in process, I mean, it could be as easy as a 3-ring binder and, you know, print something out and 3-hole paper clip, you know, and stick it in a binder or an Outlook folder or whatever it is. But just in real time, have a, you know, be keeping track of that. And this was not a plant question, I promise, because it ties in so well to this next slide. North Carolina it was one of the states that very early on enacted a statute to address limitation of liability for companies or entities from COVID-19 related claims. And there's, you know, there are a few carve outs, you know, of course, not for intentional torts, gross negligence, things like that. And it doesn't apply to workers' comp claims. And there's a policy reason for that, because workers' comp's a no fault statute. It's just meant to cover, you know, this insurance meant to cover anyone who's injured on the job. But the important piece of this statute is, like, say you had a customer or a supplier employee on your work site or at your place of business who said, hey, I came to your plant, or I came to your restaurant and I got sick, and that's where I caught COVID, and now I want to sue you. What this statute says is this is going to prevent liability for those sort of claims for a period of time. It went into effect on July the 2nd, but it's going to expire 180 days after the governor lifts the state of emergency. You know, we've been in this state of emergency order that the governor first entered on March 10. Now you have to do some things to get this protection. And the first thing you've got to do is post on your premises that you take, you know, reasonable measures to prevent the spread of COVID-19. Well, that's not gonna, you know, that's not the end all be all, but you've actually got to take some measures, you know. So that's why it's really important to be able to document that you do that. And that's why you go to different restaurants, or, you know, you go to the drugstore, the grocery store, whatever, and you see the big, you know, stay 6 feet apart. And, you know, you see the big plexiglass and things like that. So it's very clear, you know, there's a big posting on the doors that say you can't enter without a mask. So it's really clear to the public that this is a business or an operation that is taking very seriously. You have, there are other things like, some businesses, especially office environments, will send out to clients and say, these are our precautions and these are the things you have to do before you can enter our office. But it's really important that you're proactive in outwardly facing that we're taking proper measures so that you fit within this limited liability statute.
And I'll add, as we're changing slides here, I think one thing that we're reading about in the news and experiencing and also hearing from employers is this COVID burnout situation. We're all tired of it. If you're in a managerial role, I'm sure you're tired of being that broken record, reminding your employees to wash hands and socially distance and wear their mask in common areas and all of those things. But that's going to go to that protection or lack thereof that Beth was just talking about, because if you throw in the towel, it has pretty far-reaching ramifications. So I get it. We're all tired of it, but I think you're going to have to be the bad guy for a little bit longer.
Yeah. You don't want to be one of the businesses on television where everybody's packed in, nobody's wearing a mask, and you don't want to be that group. Some other developments that we're seeing, and we just want you to be aware of. We're seeing a few things. We're seeing increased OSHA enforcement, OSHA citations for not properly assessing COVID hazards. We get these updates, and we're from OSHA, and they're across the board as far as the industries that are being affected, and for various violations, for failing to train employees on use of PPE, not keeping required records. There's, this is again where we really can't emphasize enough that for your industry, go back to those CDC recommendations for your particular industry and make sure that that's what you're implementing. Face coverings are not a PPE, but they are a recommendation. So, it's just something, it's a nuance, but face coverings are definitely a CDC recommendation. We are seeing increased Title VII charges. They are not, some of them have to do directly with COVID-19. Some of them just have to do with, there's a lot of unrest in the workplace right now. A lot of unrest in the workplace. There was, as Jesse pointed out, there was parental leave litigation on the rise before COVID-19. We're seeing just an increase on a lot of Title VII. Age discrimination charges as well are on the increase. It's just, this is just I'm going to call it sort of a litigation incubator right now. People are, just nerves are frayed, and that is it, that causes litigation. So whatever you can do in your work environment to calm folks. I know that some businesses have to make hard decisions, and some layoffs are necessary. If you have to do that, please make sure that you put yourself in the best position, documentation wise, fact wise as well as possible. We're seeing increased unionizing activity. It's not only in what we see as traditional union industries. It isn't, we're seeing it in service industries like hospitality. We're also seeing this in the university setting. There was just a really large union campaign of nurses that was successful in Asheville. at what was formerly known as Mission Hospital, now it's HCA Hospital. Unions are really active right now in North Carolina, and doing a lot of not what we would call campaigns, like the formal campaigns, but they have a lot of underground activity going on. So I don't mean underground in a bad way. There's just a lot of activity going on. So just be aware of that. What that means for most of you for non-union settings is that poses the risk for unfair labor practice charges with the National Labor Relations Board. Because even if you don't have a union in place, it typically makes for an environment where there is a lot more education, just a lot more. I keep using the word activity with that, but there's just a lot more organizing and discussion about how to file unfair labor practice charges. And so we've seen some of those, and we're going to see a lot more of those. And you don't have to be a union employee to file an unfair labor practice charge with the NLRA. Any 2 or more employees who discuss terms and conditions of employment, and that can be on social media, it could be outside of work, and an employee is then let go for something related to that, they can file an unfair labor practice charge. So just be aware of that.
And that includes on social media.
So considerations for phase 3 and beyond. We've got workplace opening and we've had closing, and we're just kind of going back and forth. It sort of feels like a boomerang. So be consistent with the OSHA guidelines and those ever-changing CDC recommendations along with OSHA for COVID-19. We can't emphasize this enough. Be flexible. That's sort of the name of the game with employees right now. We know you've got to run your businesses, but communication really, really is the key here with employees. And then just make sure you're providing as much safety, equipment as possible. Sometimes even if you're not required to, try to do that, because I think the more that employees see that you're committed to their safety, that just really goes a long way to quell nerves. And we have another question.
The question is, if precautions have been posted, like a store has a sign saying they require masks, but the precautions are not being enforced, does this impede limited liability protection?
That's a great question. My mother used to always say, "We'll see." So we'll see. It's a lot harder to. It's like with anything else. If you don't enforce your rules consistently, then it's really tough to say that you have rules. So that's going to be an issue. I can't answer that question definitively because that limited liability statute hasn't been tested yet, to my knowledge.
Well, and it's interesting because you contrast that with the guidance from, I can't remember if it was CDC or OSHA, that specifically says don't have your employees confronting customers who aren't wearing masks for safety reasons. So we'll have to see how those laws or the law and the guidance kind of butt heads when they get challenged in court. But I would say, to the extent that it's your employees and not customers coming in and out, and you have some control over how they perform their job duties, by all means be consistent with those, with enforcing those requirements.
All right, so we go into phase 3. we're already seeing, spikes. So anticipate absences due to sickness. It's just going to go together. And we're seeing this week. I mean, we're seeing it through. I know Jesse and I are seeing, new court orders that are related to the increased spikes. We're going to see new orders and guidance. And we expect a different approach with the new administration. We're seeing hints of that already. With the resurgence, with the spike, at least until we get a vaccine that's implemented, on large scale, be ready if we have to or require to scale back. Again, hopefully that's not going to be the case. And we're going to rely on what we've learned since February and March. And again, documentation really is so important on plans, policies, communication, all of those great things. Jesse, what would you add to that?
I guess the only thing I'll add is, depending on what kind of workplace you have, you could consider some more aggressive precautions. Like, I know I've heard from a few employers who have a workforce that can primarily work remotely, and they've already decided to close the office until January in anticipation of folks being in more contact around the holidays, and that combined with the spike. Obviously, that's not an option for everybody, but I think it's an example of, we can wait and we can respond. And in a lot of cases, that's going to be the best we can do. But like this week in particular would be a great time to kind of visit what your options are, so you feel a little less blindsided when and if we get a stricter stay-home order, like right after Thanksgiving, which I think is totally possible.
That's a good point.
Do we have other questions? I think we've got about 5 minutes left. So we appreciate y'all spending your lunch break with us. Hopefully you are able to eat while we talk.
Thank you all so much. We really appreciate your time.
And I think, yeah, there we go. Our contact information is available on the last slide. I know several of you have had the pleasure or the problem of working with someone from our L&E team before now, but if we can help in any way, let us know.
And we continue to post updates on our website as there are changes at the state or federal level. So continue to check our website, and we'll continue to push out information as it comes along. So thank you all so much. We really appreciate each of you.
And we've had a couple of questions come in asking if we'll be providing the slideshow, and we'll be sending it out to all the attendees.
Great. Thank you, Victoria. Thanks, Victoria, for all that you do to make this happen for us.
Thank you, guys.
Have a great afternoon, everyone.